Good afternoon. So this dude, Two Truth for Liberty, loves to haunt my comment sections, acting like he knows what the hell he's talking about. And I fired warning shots across the bow in my rambling while ambling, but he still seems to think that he's smarter than I am. And he is calling me a liar. So you and I are going to look at the evidence and see if I'm lying or see if he is just incredibly misled. So the first thing, he even gives timestamps because he's that kind of dude. He says that I claim that the Seventh Amendment guarantees your right to an attorney. Well, this is from my Rambling While Ambling 12219 video. You could find it under a Stephen Tunis comment. Down here, he says a lawyer does not have to be licensed. We're talking about lawyers, licensing. Members of the state bar are licensed. Okay, technically, sure. What is the bar? A list of the field of persons who have been admitted, allowed, permitted to represent others in court and to attend other legal matters. And that is true. And it's not just states that have bars, because you have to actually enter the bar for like the Western District Federal Court of Western District Ninth Circuit Court, or there's different district courts in California, and you actually have to be admitted to the bar to argue in front of them. I'm going to take a sip of my delicious Rockstar. Go Fuel. Okay. So a list of the field of persons who've been admitted, blah, blah, blah. It's created as an attempt to ensure the field of those who represent others in court. So he's using represent as a state bar attorney. That's the way he's using the word represent. He really means practice law, but I'm understanding what he's saying because he's talking about attorneys. It is created as an attempt to ensure the field of those who practice law for others in court and other legal matters, or at least minimally qualified to do so. That said, the bar restriction cannot violate a party's, and then he put in Sixth Amendment right, and he's changed it here to Seventh Amendment right. Thus, states, all that I'm aware of, allow for an incompetent or incapacitated person to sue by employing functional, meaning not necessarily by monetary contract, a next friend to represent them before the court or in other legal matters. So he's using the same word. Now, if he just said next friend as to sue in their name or accept a settlement agreement, things like that, fine. But he's not. He's not. And you can see it here because he's talking about attorneys representing in court and representing them before the court. As such, a member of the bar, i.e. attorney, must be licensed, but a lay lawyer need not be licensed. Wrong. Wrong. In California law, being unconstitutional insofar as it would be contradictory. It would depend on holding yourself up as a lawyer means. P.S. Even if representing yourself, you still have the right to assistance of counsel, and with counsel does not have to be a licensed attorney or even a lawyer. That is wrong. That is absolutely wrong. Your right to assistance of counsel is a Sixth Amendment right. He's all confused in his head. I probably should have Sixth Amendment up and Seventh Amendment because they are different. I can't see what I'm typing with this big old... All right, so that's the Sixth Amendment, and we'll do the Seventh Amendment too. Delete. All right, so the Sixth Amendment says, and you have the assistance of counsel for his defense. I'll read it all to you so you don't think I'm hiding anything. It says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, and which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have my eyeball itches, and to have the assistance of counsel in his defense. The Seventh Amendment says a whole lot less. It says, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States, than according to the rules of common law. So there's a lot of There's a lot of different sections in the Sixth Amendment. There's only two. You have a right to trial by jury and the reexamination clause. So there's only two clauses in there, and neither one of them say anything about having an attorney. So where were we? So he did claim that the Seventh Amendment guarantees you some sort of right to an attorney. We just saw that. It'd be unconstitutional to say that. So you have the right to assistance of counsel, is what he's saying in here, but it doesn't have to be a licensed attorney or even a lawyer, and that's wrong. He was relying on the Sixth, and he edited it sometime later. I don't know when he edited it, but we didn't get there. So that's wrong, number one. Merbies has said that Two Truth for Liberty claimed that the next friend can act essentially as an attorney ad litem. False. Next friend can represent, specifically sue and represent. Well, as we just saw in here, it said specifically he's talking about lawyers being able to represent others in court, and next friend to represent them before the court. In the same paragraph, I think that's a paragraph, I'm not entirely sure, but we can see the context of what he's talking about. And he even continues that you have the right to assistance of counsel, even a non-licensed attorney or a lawyer, and a member of the bar, i.e. attorney, must be licensed, but a lay lawyer, whatever he thinks that is, because he is a sovereign citizen, need not be licensed. That's wrong. He says the California law being unconstitutional insofar it would be contradictory. Yeah, no, you can't represent yourself, or you can't represent anybody else in court without a license. He relies on different test argument, which is a red herring. No, it's not. They have different tests. So, the right to counsel under the Sixth Amendment, this is Lewis v. United States. This fair opportunity, they have to have a fair opportunity to secure the counsel of their choice. That's one of the many things they have to do. That's one of the tests. There is no fair opportunity test in the First Amendment. There is no fair opportunity test in the Second Amendment. It's a different test. It's a completely different test. And this is Lewis v. United States. It is a Sixth Amendment case, but you can see very clearly it says a defendant has no right, for example, to an attorney who is not a member of the bar or who has a conflict of interest due to a relationship with the opposing party. No right to an attorney who's not a member of the bar. No right. None. Zip. Zero. Nada. I won't say Nathan. I don't want to offend anybody, but it's part of my little spew. So obviously, he's wrong. This is McDonald. McDonald says we have previously held that most, look at that, most of the provisions of the Bill of Rights apply with full force to both the federal government and the states. And that is true. Most of them do. But then again, if you look at the Seventh Amendment, it would be the right to a trial by jury in a civil suit where it would exceed $20, and won't be re-examined, the re-examination clause, other than according to the rules of common law. So that's McDonald, but you notice it says most of the provisions. One of the things that you should be aware of, and I did highlight it, awesome. The seventh, it says the First Amendments, blah, 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 are not considered state action, deal with only federal action. We select from a multitude of cases of those we deem to be leading, and as a necessary corollary, that the Seventh Amendment applies only to proceedings in courts of the United States and does not in any manner whatever govern or regulate trials by jury in state courts or the standards which must be applied concerning the same. This is a U.S. Supreme Court case, Minneapolis and St. Louis Railroad Company v. Bombolis. It is from 1916, but it hasn't changed since then, I assure you. Please look to find where the Seventh Amendment applies anywhere to a state. It does not. Let's see, what else do we got here? So yeah, the different test is not a red herring. There is a reason why When the court is talking about Fourth Amendment issues, it uses Fourth Amendment tests and Fourth Amendment precedents. When it's talking about First Amendment tests or issues, it uses First Amendment tests and it uses First Amendment precedents. When it's talking about the Seventh Amendment, likewise, it will use Seventh Amendment tests and Seventh Amendment precedents. You can't pick a single sentence from a completely different line of cases and expect it to be not dicta. It would be misleading to be used in the wrong case line anyway. Merbies relies on a probate argument, which is a straw man of his own making. Merbies claimed it's related to probate. So probate, that was, I think that's in here. This is not guardian. This is not children. This is not family law, right? And I said somewhere in here, I think I said somewhere in here that it is probate, not family law. I said it somewhere in here. It was probate, not family law. Do. Oh, well, somewhere in there, you could see that in here he was saying that he thought that I was talking about family law. He thinks that guardianships are family law, and they're not. Guardianships are in the probate code in California. They used to be in the probate code of Texas. This is a case out of Texas. This is a Texas Court of Appeals case, Texas State Court of Appeals for the First District of Texas. And in here, you may notice he referenced To Truth for Liberty referenced Rule 44 as well. Rule 44 looks very similar to see in the parties section of the federal rules of civil procedure. They talk about minor or incompetent persons, and a minor or incompetent person that does not have a duly appointed representative may sue by a next friend or by a guardian ad litem. The court must appoint a guardian ad litem or issue another appropriate order to protect a minor or incompetent person who is unrepresented in an action. But again, this is under parties, right? It's looking at plaintiffs and defendants. And this is under, they may sue. The following representatives may sue or defend, sue or be sued, on behalf of a minor or incompetent person, a general guardian committee, conservator, fiduciary, and if they don't have a representative, then it can be with a guardian ad litem or a next friend. So yeah, they're not talking about attorneys, but I'm sorry, going back to this one, which was McCrimmon v. Taylor. Neither Green nor McZeal is a licensed attorney, but they attempt to prosecute this lawsuit pro se on behalf of McCrimmon and Cretton. They urge that Rule 44 does not provide for a procedure for appointing an ex-friend and does not require an ex-friend to be an attorney, and thus they should be allowed to act as next friends. They rely on Saldariaga v. Saldariaga for the proposition. However, in Saldariaga, the Court of Appeals held that the proper method of appointment for an ex-friend to another adult is to follow the same procedure for the appointment of a guardian ad litem set forth in Texas Rule of Civil Procedure 173. So you appoint a next friend in Texas the same as a guardian ad litem. You can see that in the federal rules, they are suggesting that you do the same as well. They're suggesting you do the same as well because it may sue by an next friend or guardian ad litem. The court must appoint a guardian ad litem or issue another appropriate order. So it is to appoint a guardian ad litem or equivalent. In addition, the probate code. What? The probate code provides a procedure for establishing a guardianship. And in this case, the court never appointed them as next friends, etc. But the point is that number one, you can't under Texas law, you can't represent someone. Up in here it says Texas Rule 44 allows minors, etc., to be sue and be represented by an ex-friend. Represented, right? The Texas Rule of Civil Procedure, however, does not violate Section 81.102 of the Texas Government Code and allow unlicensed persons to practice law through appointment as a next friend. Rather, persons must be members of the state bar to practice law in Texas on behalf of others. Texas Government Code annotated Section 81.102A, Vernon. The Supreme Court may promulgate rules allowing others to practice law in Texas, but that power is limited to the practice by 1, attorneys licensed in foreign jurisdictions, 2, bona fide law students, and 3, unlicensed graduate students who attend or attended a law school approved by the Supreme Court. So there you go on that. In addition, this is a district court case. You're like, why are you citing a district court case? Well, because it cites a whole bunch of other cases that are citable, and it's just easier for me to do this to show that there are a bunch. And this is just Fifth Circuit. Mary Ruffin brought this lawsuit as a pro se litigate on behalf of her minor son, KF. Plaintiff sues defendants Houston International School District and ABC East under the Individuals with Disabilities Education Act, et cetera, et cetera. Defendants have filed separate motions to dismiss, each arguing inter alia that Ruffin may not represent plaintiff in this lawsuit because Ruffin is not a licensed attorney. Having considered all the matters of record and applicable legal authorities, this court concludes the defendant's motions to dismiss should be granted. The Fifth Court has not squarely addressed the related issues at bar, whether a parent pro se can represent her child in federal court in a lawsuit brought under IDEA. The Fifth Circuit has held, however, that individuals who do not have a law license may not represent other parties in federal court, even on a next friend basis. See Weber v. Garza, finding that individuals not licensed to practice law by the state may not use a next friend device as an artifice for the unlicensed practice of law. Also see Guajardo v. Luna, holding that an individual who is not admitted to practice law is not authorized to appear in any court to represent a third party. Other circuits that have considered the issue have uniformly prohibited a non-attorney parent from representing a child for the claims such as those asserted in this lawsuit. The Fifth Circuit has not explicitly adopted this rule as to the claims Ruffin asserts here, but has endorsed the principle that a non-attorney parent cannot appear pro se on the behalf of a minor child. See Harris v. Apfel, citing Devine v. Indian River County School Board. Johns v. County of San Diego. Osiafriye v. Medical College of Pennsylvania. Meeker v. Kircher. Although the Fifth Circuit ultimately held in Harris that a non-attorney parent is permitted to sustain a pro se action on behalf of a minor child in Social Security appeals, it distinguished those cases from others, thus indicating that a non-attorney's representation of a child was prohibited for other types of claims. See Harris. Ruffin accordingly may not represent plaintiff in this IDEA Section 504, a 1983 lawsuit. The ruling is not a surprise to Ruff, blah, blah, blah. It's ordered, et cetera, et cetera, et cetera. So you can see this is not a surprise to anybody, and he was just being super duper silly. Why is it a straw man? It's related also because related to anything that can be brought in civil suit. Okay, so the issue here is it's not that you can't be a next friend in any suit. You can sue or be sued in any field. The problem is that you become a next friend because there is an incapacitated or minor child. Incapacitated person or a minor child. Incapacitated persons and minor children are addressed in the probate code. Texas has recently moved their probate code into their estates code, but whatever. It's the same difference. That's why it is the next friend is a probate issue, or now in Texas, it has changed to estates, I think 2 years ago. In fact, we could do it. We could look it up. Texas Constitution, statutes. And we're going to look at Texas statutes, and we're going to go to the probate code, and we'll see the substance of the Texas probate code was codified in the estates code by the 81st and 82nd legislatures. And for that reason, the Texas Legislative Council is not publishing it. They've just moved it into the estates code. It is the same thing. About the principle of various amendments also protecting prerequisite to truth or liberty, comment as follows, begin quote. The Lewis case was cited as only one example. Yeah, we dealt with that. The Lucas case expressly stated that there is no right to a non-bar member attorney. And there you go. Everything specific to the Sixth Amendment from Lewis v. U.S., including citations to other cases inapplicable to whether or not general principle exists. Yeah, general principles are wonderful. The problem is there is specific case law. There are specific tests. So general things are pretty stupid. He says that how do they know that the general principle, constitutional rights, protect the necessary prerequisites for their exercise? The first thing you have to establish that there is a constitutional right. You did not do so. So if there is a constitutional right to an attorney, a non-bar member attorney, to practice and represent by practicing law as a next friend, an incapacitated person, if there was such a constitutional right, then yes, it would also protect all the necessary prerequisites for that exercise. But there's not. That's the problem you're running into. You haven't established the constitutional right yet. That's the first step. And then even if there was one, then you would look to see if there was case law about it. And if there wasn't case law about it, I'd be really surprised. But if there wasn't, then you could start making a good argument. But you have to first establish there is a constitutional right. And since the Seventh Amendment does not address it, the Sixth Amendment certainly doesn't address it because that's only in criminal cases. But the Seventh Amendment doesn't address the right to counsel. So you would have to infer a right to counsel, and that would have to come out of actual case law. You would need to have a case. And since you cannot come up with a case establishing the constitutional right, you're just dead in the water right there. Because this principle has only been applied concerning the Sixth Amendment, but it has also been applied to other constitutional rights, such as you cannot ban all handguns in the Second Amendment context. Okay, but again, the right to act as an attorney is not banning handguns. And in the First Amendment context, the well runs deep on the number of things protected as prerequisites concerning free speech. Yes, but the Constitution expressly states that you have a right to keep and bear arms. It says that. Those words are there. Nobody has to infer it. The Constitution expressly says you have the right to freedom of speech. It expressly says it. It expressly says that you have a right to counsel in a criminal matter. It expressly says it. The problem that you continue to run face first into is the Seventh Amendment. No amendment, nothing in the Constitution says that you have a right to an attorney in a civil action. Full stop. There is none. And beyond that, there is certainly nothing in there that says you have the right to select a non-bar member to act as your attorney. The Constitution itself shows a constitutional right to trial in the Seventh Amendment. It doesn't actually show a right to trial. It just says if there is a trial, then you have a jury. But you also have to remember that you can't sue the federal government unless the federal government gives you a cause of action. So that's the problem. And again, he repeats himself, the constitutional principle that prerequisites the constitutional right is protected. You haven't proven the constitutional right. And again, you just saying it doesn't make it happen. So you're wrong there. In the case of the Seventh Amendment civil suit, the protected prerequisite of counsel representation for an incapacitated person who is currently incapable of exercising the right to file and put on a civil case. You seem to have missed the fact that you are pulling the right of a next friend out of the federal rules of civil procedure, not the Constitution. That is a huge failing on your part and something that a lawyer would not have overlooked. Meanwhile, even though there's a plethora of cases where an ex-friend has represented others in courts, there's no case showing a prevention of an ex-friend from representing an incapacitated person because having such representation, non-attorney counsel is not a right. Again, yes, we have. We've seen that, because just because you're too lazy to look it up doesn't mean that I'm too lazy to look it up. I knew ahead of time. I have always known. You're stupid if you think me asking you for a case doesn't mean I don't know. It might mean I don't know, but it doesn't mean I don't know, if that makes sense. I may or may not know the answer prior to me asking you to cite something. When the opposition repeats the same leaky and unsubstantiated argument over and over again, especially considering procedure, oh no, he said he misspoke, that should raise a red flag. You said you misspoke, sir. I never said I misspoke. You said you misspoke. You said edit 7th, not 6th. You said a long way down. So I obviously misspoke. I mean, we did a lot of battling here before you realized, in air quotes, that you misspoke. And you only realized you misspoke because I made it very abundantly clear with actual citations to cases that you were wrong, and so you had to switch. You are the reason why I said that people like to move goalposts. And then he says, end quote, as can be seen in the claim by Two Truth for Liberty, the principle that is the principle of protecting prerequisites, the exercise of fundamental constitutional right applies to all fundamental. Yes, okay, fine, sure, but you still haven't established your right to a counsel in a civil case as a fundamental constitutional right. It has been shown by the court that even the unenumerated right to abortion protects prerequisites. Yes, but there was no right to abortion prior to the court making it. That's why we can point to Roe v. Wade and subsequent case law as there is a fundamental right to get an abortion up to a certain stage. Bleh. The list of rights to which that principle applies is long, and you don't be claiming to be citing all of them, but there's more than enough to establish the principle is applied to the courts that matter. Yes, but if it is not an enumerated kind of right, if it is what they call a substantive right, then the court has to state it exists. Like there is a right for two people to live together. You have the right to live with your spouse. Right? That's not the Constitution. The court made that up. The court made that up. But you could actually point to a case that says that. You have the right to, I don't know, live with your family members. Like a father can live with his son. A mother can live with her daughter. A grandparent can live with a grandchild. And that's a constitutional right, but you could actually point to a case that holds that. And therefore, since a next friend can be a prerequisite of an incapacitated person to exercise their fundamental right to sue in court, that's not, I would love to see a case law that says that is a fundamental right. The premise of Two Truth for Liberty, as it has been from the beginning, is that some people can be represented in court by a non-attorney, has not been refuted, except it has, by case law. It has been refuted by case law. Just in the Fifth Circuit, there was Weber v. Garza, I think was the big one. Yeah, that was in 1978. But there's new ones, and that's why I picked this case, because it lists a whole bunch of them. A whole bunch of them. And you, sir, are a sovcit. Thank you very much for watching. I think I have clearly established, showing actual evidence and cases that Two Truth for Liberty was incapable or unwilling to cite. I think I have done my job. Thank you very much for watching. Two Truth for Liberty, you're a liar, you're a sovcit, and you don't know anything. And I really would wish you'd stop giving advice in my comment section, because you give terrible advice, and you're a bad person, and you should feel bad. Thanks for watching. Have a great day.